नमस्कार दोस्तों। किसी भी बिजनेस की सक्सेस काफी हद तक उसकी वर्कफोर्स पे डिपेंड करती है और एमएसएमईज के लिए हमेशा ये एक इशू बना रहता है कि कैसे वो अपनी वर्कफोर्स को रिटेन करें, उनकी प्रोडक्टिविटी इंक्रीज करें, सारे एचआर कंप्लायंसेस को फॉलो करें और इसके साथ इंश्योर करें कि उनकी ऑर्गेनाइजेशन में कभी भी लेबर रिलेटेड कोई डिस्प्यूट ना हो। कुछ इन्हीं टॉपिक्स को मैंने आईसीएमपी के साथ में अपने वेबिनार में काफ़ी डिटेल में डिस्कस किया था, जिसमें मैंने बताया था कि कौन से वो ऐसे मैंडेटरी लेबर कंप्लायंसेस हैं जो सारी एमएसएमई ऑर्गेनाइजेशंस को फॉलो करने बहुत ज़रूरी हैं, कौन से वो ऐसे एचआर एग्रीमेंट्स हैं जिनसे एक ऑर्गेनाइजेशन को मदद मिल सकती है, about the legal steps to prevent the labor or HR related issues, and also about the legal steps to follow in case of legal disputes. So let's get started in 3, 2, 1. To start with, firstly, the employment and labor related issues. So now there's a differentiation between the employee and the labor. Like we all know, labor will be the manpower which is there on the machinery, जो हाथ का काम करें basically, and employees are the one who are more on the other side, like handling the finances in the accounts department, the marketing department. So when I talk about the employee related issues, so firstly it comes like employee retention, because these days the MSMEs, even the hiring part is it also very time consuming and a lot of resources are involved to hire an employee and to train them, and in the end if they leave abruptly and without a handover, you're not able to retain them, that affects the whole working. So that is one issue which is being faced by the MSMEs. Other issues could be like the breach of contractual obligations. At times, like an employee, if they're working with you, you give them with proprietary information. They have all the relevant data. If the person is involved in marketing, so they basically know what your clients are, what your quotations are. So later on, what if they join the competitor and provide all that details to them? So that could basically affect the whole business of an MSME. So that is one of the problem. And later also, if that employee also leaves and start a dispute stating that they have not received their money or any bonus or something like that. So these are the issues which on the employee side, these are the issues. But when it comes to labor, the issues are altogether very different, because if like some certain manufacturing is involved in the company and suppose there's an accident at the workplace, so what to deal with then, like what should be done at that time? Because whenever such thing happens, besides all the labor related issues, there could be a criminal case involved, there could be an FIR registered. That is how it happens mostly. That is one case. Second could be a misconduct, because on the employee side, like all of that is governed by the appointment letter, which I'll be coming to later during this presentation. But when it comes to the labor, there are all together very different acts, how you deal with them, how you deal with the misconduct. It's not like you hire a laborer and if he's working with you for a while and then you can just remove them right away whenever there's a misconduct. That cannot be done. Like certain steps have to be followed. You have to do an inquiry, you have to give him a show cause notice, a charge sheet has to be submitted, he has to be given a fair opportunity. So all of that, how to deal with that. And later on comes the compliances. There's certain compliances there, ESI, the PF. All these are the issues which are there. Now to start with the preventive measures, how to prevent an issue, like all these issues which we talked about earlier in the presentation, how to deal with that. So firstly, how can we prevent it? So first thing could be a background check. Now I understand like big companies, they can hire a professionals to do all the background verification, but with the limited resources, there's not much which an MSME can do. But yeah, you being an entrepreneur also can do certain background check without incurring any expenses also, because while doing a background check, you basically see where the employee is coming from, where has he worked before, and what his previous organization was, and checking like if while he was working there, he left the company, he was terminated, and what all happened. So by asking the documents, but yes, the documents can also be fake, but an easier way to check that is that getting his because he must be having a PF number, right? So through his PF details you can actually verify that where he was working before, and maybe calling their HR or making some communication, you can have a fair idea like where the employee is coming from. And if you're hiring someone for a prominent position, it is very much important to do a background check if a person is coming from marketing or someone like that, because at times what happens is that while you conduct a background check, at times these marketing people, what happens is that they already are, they might be working with a competitor, they might have not disclosed you or something like that, or they might be having some issues there also. So once you do a background check, you get to know like if the person coming, is he coming clean, and are there any issues associated with him or not. Second thing is you do proper documentation. Like if you have a proper appointment letter whenever you hire someone, I think half of the issues are gone. If there's a proper appointment letter, all the terms are properly stated, all their expectations, what their obligations are, what you would be doing. If all of that is written in a proper manner, it is signed, it is acknowledged, most of the things can be handled at that very stage. So a proper employment, I'll be sharing the later on, I'll be sharing a draft with you to tell you what all conditions and what all basic terms should be there in an in an appointment letter or an offer letter if the letter is signed before. All the documentation starting from the appointment letter, and if during the employment also, if you have like standing orders, if you come to that purview, or a HR policy, all of that should be there. And also documentation, like if you're terminating someone, if you are issuing a show cause notice, even if while doing their full and final, like while a proper exit, the documentation should be correct. So that solves most of the problem. That is like very cost effective. You don't have, once you have all the drafts ready, you just have to use those drafts. It's not that you're incurring any expense over that. So these documents should be there so that this could prevent a lot of issues. Compliances, see, there is no end to HR compliances. I won't be able to even cover all the compliances if you talk about, but the basic compliances, which I think most of the people attending this webinar, mostly MSMEs. So the basic compliances which I should talk about is the ESI, the PF, in gratuity. These three things, if they are covered, I think most of the part is covered. Nothing much is expected out of an MSME. But these three things are there, and these compliances, I think most are not just compliances for the sake of it. That actually prevents the interest of MSMEs also. Like if I talk about the ESI, if you're paying the ESI, and if, like I was talking about the accidents earlier, if something of that nature happens, I think most of the part is taken care by them only. Your liability does not even arise if you are properly complying with the ESI Act. And like, because I'm talking about preventive measure, if you follow the due process, if like while hiring, while retaining an employee, while making them leave, if all of these things are followed, the due process, you could lay it down. If you have a proper HR in your organization, even if you don't, if organization is not that big, but if you lay down a due process of everything, I think all these issues can be handled. And also like timely action. At times what happens is that we think we don't act in a prompt manner. Like if you're terminating someone, if we receive a notice from them, at times we don't take action quite soon. But whenever like labor related problems occur, you should act soon. If an accident happens in an organization, if you're just negotiating with them, not even seeing if we have all this documentation, we have intimated the ESI, everything. So timely action is also important, because we should not delay all of this. If the matter, like later on I'll be discussing about the dispute, so I'll be telling you what timely action actually means. So now coming up with, like I was telling about the preventive measures, firstly what comes is the HR agreements and documents, starting with the employee offer letter. So now firstly I'll be taking care of the employee part, not the labor part. So when it comes to the employee part, like an offer letter is something which is signed before the actual employment agreement. So it basically has what are you offering, and if the offer is accepted later on and he is actually appointed. So the difference between an offer letter and an actual appointment letter is that once if he agrees to the offer, and then maybe you can share the appointment letter with him. So the basic offer should be there, like name, details, everything should be there. The position he's being offered, what is the compensation, and compensation should actually be split, like what is his basic salary, what is the variable salary, what are the benefits that are being offered. I'll be sharing a draft with you, so so that you can actually see to it. But at times, also, like when we talk about the offer letter, there's a clause I think which should be there, is that if you are actually taking pains and maybe you're hiring some outside agency to taking care of the recruitment, then if person accepts the offer letter but later on if he does not join, so maybe that clause is also there, like if a person accepts the offer but does not join, so a certain penalty is associated to it, because you're incurring expenses, you're anticipating that he'll join and he does not join, so that affects the work, so that you have to go through that entire process once again. So it is important to have, like if you're even offering someone, it's better to have an offer letter, and later on if he actually joins, then an appointment letter. Now, like employee contract, so let me actually share the employee contract with you, so that you have a fair idea what all terms should be there and what those terms actually means. Because see, what happens is that, like, initially I think the drafts which are there, and which most of organizations, the drafts which they use, they do not cover the scenarios that are happening currently, like the things that used to happen 10 years before, the kind of disputes which were there related to an employee, the nature of disputes and everything, it has altogether changed in all these years, with the internet coming, with uh, so many, like even the sales, most of the sales these days, it happens, all these sales happens to Trade India, India Mart, and everything. The uh, the data is very much important, which was not there. So uh, seeing that importance, and seeing, so there are certain changes that are being made, like the employment contracts these days are very different. So let me share it with you so that it covers, I could tell you what the important conditions are and what do they actually mean. Can you see this, the document that I'm trying to share, the terms and conditions?
Yes, it's visible.
Yeah. So, like I was telling, what all conditions should be there in appointment letter, starting with the title, joining date, salary. I think these are mostly taken care by most of the, like, these are there. Uh, you should mention the TDS or any tax which you'll be deducting, but I think it's there. The working hours should be there, what is expected, what the lunch break would be. Important is the probation period. This should also be mentioned, because at times you're hiring someone, you don't know if he she is actually suited for the organization or not. So 3 months probation period is there, so that you can terminate them without any notice period or any those obligations. So you can mention that in the probation period, and you can also mention that if the probation period is just for you or for the employee also, that employee can also leave without notice period, or it's just the employer who is taking this benefit. So this can go unilaterally also, like it could be in a way that only the employer has this benefit of terminating the employee during the probation period of 3 months or 6 months, and not the employee who can leave. The duties and obligations, the basic duties and obligations, you can mention what all is expected, what is there in your organization, the work culture and everything. All of this are quite standard, but at times if later on you want to terminate them, then all these conditions become very much important, so that you can say that there was actual breach of these conditions. Now, termination by the employee, here comes the part of the notice period. Like you can mention that how much notice period is required to be given by the employee, and how much by the employer if they actually get terminated. Like this mentioned 1 month's notice, or the salary in lieu. That means, yeah, either the employee is expected to work for that 30 days, or he can actually give away his salary, whatever is suitable for the organization. That is to be mentioned. Now, coming to this part, the restrictive covenants is what I was talking about. Like these days, you need to cover all of that. First is non-disparagement. Non-disparagement clause would mean that if what happens these days, that like due to social media and all, when the company, when the employee leaves the company, so he start posting some things about the company कि यहाँ पे काम अच्छे से नहीं कराते, यहाँ कुछ गलत करते हैं, वर्किंग कंडीशंस ठीक नहीं, कुछ बुरा भला कंपनी के बारे में बोलना. सो ऑल ऑफ दैट यू मेंशन फर्स्ट इन द एम्प्लॉयमेंट एग्रीमेंट इटसेल्फ, कि यहाँ पे रहते हुए या यहाँ से निकलने के बाद यू कैनॉट basically defame the company and everything in the social media or anywhere else. and also the sort of compensation associated to it. Now you can obviously say that कि once the employee leaves, एक बार चला जाएगा तो how will you actually ensure? But all of this ये होने से ही employee पे effect पड़ता है कि that he is not supposed to do all of that, and because of it, that effect, the chances of actually happening it also they lessen. Now non-competition, non-solicitation is something which I wanted to talk about. Non-competition would mean that अगर आपकी you have an organization like most of you are associated with corrugated boxes. If a person who is associated in who is employed in sales, if he joins a competitor, he has all the client list, he has all the quotation, so chances of all that business going there also increases. So now if you mention in the agreement itself that okay, you being a salesperson can join as a sales employee anywhere, but not in a company that is into corrugated boxes, so that you mention this here, so this has a deterrent effect and you can actually stop them from doing so. अगर वो इसको करता है तो you can file a case, but वो तो चलो बहुत आगे की बात है कि उसको वो करेगा तो क्या होगा, but ये होने से ही like lot of things, एक preventive step तो है ये, that they know that they have this understanding that they cannot do so. Non-compete clause, like all this mostly senior management in senior position, they have this clause of non-competition and non-solicitation. Even like opening his new company, like if a person who's very senior, who is manager, or if he's wanted now he has all the know-how of the company, like how is everything happening and how you're conducting the business, so he says that okay, that why not I start this organization myself in that same area, because he would have an unfair advantage. At times what you do is that a person in MSME, he's handling something and major part to किसी और को देता है चलाने के लिए, and उनको लगे हम we are doing it for the employer, why don't we do it for ourselves? So this, having these clauses there in the appointment letter, all these clauses help a lot, so that they're not able to do that business or to join a competitor. Also what happens that this also covers the fact that okay, they cannot do it indirectly also. At times what happens is that a person who is employed with your organization, they parallelly start a new business in their wife's name, in their parents' name, or something like that. So all of that, all scenarios are being covered by this. I'll be later sharing this so that you can also implement in your company if required. Indirectly, directly, joining a competitor, starting or their own business, everything is covered in this. Now coming to conflict of interest, that is also like I think dual covering the part like okay, they cannot do any other work that is conflicting with you or has to exclusively work for the company, not that on their side they're handling some other work. At times accounts people, they do that, they're handling your accounts and later in the night or they handle some other account also. You can mention it there, that is up to you if you're allowing that or not, but mentioning it also has a detrimental effect on them कि कल को वो करेंगे तो उनको पता होगा हमारे एम्प्लॉयमेंट एग्रीमेंट में था, एंड बेस्ड ऑन दैट इफ इट कम्स टू, यू कैन एक्चुअली fire them or terminate them, because this would be a direct violation of the terms which were there in the agreement. Rest are actually detailed terms, like what are, I cannot cover anything, everything at this stage, but yeah, all these clauses which I am just going through are very important. Confidential information also, this clause is also there, because like I was telling, during like nowadays data is very much important, and if the employees who are working with your organization, they have access to and they are being given the certain data and digital information, so now it becomes duty of him to keep that data confidential and not to share it with anyone during the employment, even after that. Like in these clauses we cover that this confidential information should remain with them, like when they leave they should hand it over and not use it anywhere. And if certain know-how is there, because अगर आपके कोई पर्टिकुलर डिजाइन है, कोई टेक्नोलॉजीज है आपके बिजनेस में, कुछ इस तरह कोई नो-हाउ है, तो वो आगे उसको पास ऑन ना करे. All of this is there and this covers everything. So having this clause would help you a lot. Intellectual property, trademarks, अगर आपकी कंपनी का नाम कल को like if an employee associated, because this actually happens कि अगर कोई employee आपकी कंपनी में associated है तो लोग उनको उसी के नाम से जानना शुरू हो जाते हैं, तो कल को अपनी कंपनी खड़े कोई और काम करे उसी नाम से करना शुरू कर दे, So this is covered, like that is your intellectual property, your trademark, your trade name. So this can also not be used by the employee anywhere. कंपनी प्रॉपर्टी, दिस मेंशन दैट अगर आपने कोई उसको लैपटॉप दिया हुआ है, छोड़ने के बाद वो लैपटॉप नहीं दे रहा कि पहले मेरा हिसाब करो एंड एवरीथिंग. सो ऑल दिस क्लॉज आर आल्सो कवर्ड, लाइक कि कैसे उसका प्रॉपर एग्जिट होगा, कंपनी प्रॉपर्टी को कैसे रखेगा, अच्छे से रखेगा, नहीं रखेगा. बिकॉज दैट टाइम आप उनको लैपटॉप दिया, वो जब जा रहा है तो वो तोड़ के जा रहा है कि, या फोन है कुछ इस तरीके का है, तो वो प्रॉपर्टी उसके पास कैसे पड़े रहेगी, हाउ दैट ही हैज टू टेक अ प्रॉपर केयर ऑफ ऑल दैट प्रॉपर्टी एंड एवरीथिंग. लाइक ही हैज टू रिटर्न दैट प्रॉपर्टी विद इन अ रीजनेबल टाइम. इंडेमनिफिकेशन ऑल्सो, लाइक ड्यूरिंग द एम्प्लॉयमेंट अगर उसको कोई डायरेक्टली इनडायरेक्टली कोई नुकसान होता है तो आपके ऊपर ना डाल दे. सो दिस क्लॉज कवर्स दैट. जुरिसडिक्शन इज ऑल्सो इम्पोर्टेंट, कि कल को कोई डिस्प्यूट होता है तो डिस्प्यूट कहाँ जाएगा. कवर एम्प्लॉय रेट, बिकॉज लाइक वी ऑल नो मोस्टली क्या होता है, दिस इज ऑल्सो लाइक lot of people not aware that whenever there are certain dispute with the employee, that those disputes do not go to the labor court. They are not labors as such, they do not come in that definition. So whenever there is an employee related dispute, a person who is employed with you but not as a labor, so that those disputes go to civil court. And if your company has multiple offices, so in that agreement only you can decide where that dispute would actually go. And if you this is one office, like you switch it in Faridabad, Gurgaon, to because you the cause of action arise there, the matter will go there. But if there are multiple offices, multiple locations, so you have to decide, like you can mention it where the matter would go. You can also have a arbitration clause altogether, like the matter will be referred to an arbitration. Due to all this, what happens is that because arbitration for an employee, it would be very difficult for him or her to actually invoke it. So by putting this clause, you are minimizing a dispute, because filing a case in civil court is much easier. But if there's an arbitration clause, arbitration has to be invoked from the high court. So अगर कोई employee है, there's certain he she thinks that there's a dispute, now for him or her to go to the high court for a case with the company, और उसको इतना amount भी नहीं है, वो possible ही नहीं होगा. So by adding all this complexity, and lastly this, they would be governed by this clause. It's not that they go to the civil court and say that I signed it just like that. You're taking signatures on this agreement, and it becomes binding on the employee. So for it becomes easier for an organization if there are lesser cases, and by having these type of contracts, the cases actually go down. Also, like now you're taking the acceptance, so it's like I was telling you, having a background check. So in the employment agreement itself, you can take all those documents from them, what all documents they are submitting, like proof of age. This becomes important at times because कई बार क्या होता है, जो age that has been given by them is not correct. So whenever it comes to retirement or all these issues, age also becomes a crucial factor. So you're taking the proof of age from them only. The certified copies of their educational and professional qualifications should also be taken. Their experience certificates, from their experience certificates, you can actually do a background check on them. Their relieving letter from their last employer, their salary slip, all of this, I think you will already being taken care of. आप लेते ही होंगे, but better है कि आप इस सारी चीज़ें को कुछ miss ना हो. It is there. Their residential proof, their latest photographs and everything, their PAN card, and then you take their signatures. It is better you take their signatures on all the papers, so that they cannot say that ये clause तो हमने पढ़ा नहीं था. And now quickly, this was for the employee, and then I'll be discussing आपने labor से क्या लेना, because those are also your employees. So it is better even if for the workforce which come under labor, उनसे भी आप एक लिखित में उनसे ले लें कि हिंदी में, because labor they would not be knowing English, so it's better कि उनका जो नियुक्ति पत्र है वो भी in place हो. कोई भी इशू कहीं भी आता है labor related, so they first thing they ask is submit the appointment letter, the नियुक्ति पत्र basically. इसमें वही बेसिक टर्म्स जो वहाँ थी, यहाँ पे उतनी डिटेल में नहीं जाएंगे, बिकॉज नॉन सॉलिसिटेशन लेबर के लिए आप नहीं कह सकते कि कॉम्पिटिटर को ज्वाइन नहीं करेंगे, वो उससे वो एक्सपेक्टेशंस लीगली आपकी हो भी नहीं सकती. द बेसिक एक्सपेक्टेशंस व्हिच कुड बी देयर फ्रॉम अ लेबर आर मेंशन्ड, लाइक दिस इंक्लूड्स द बेसिक डिटेल्स. व्हेन इज द उनकी नौकरी स्टार्ट कब से हो रही है, बेसिक उनकी सैलरी कितनी है, वेतन कितना है, कितना पार्ट उसका ESI में जाएगा, कितना पार्ट PF में जाएगा. इट इज बेटर यू मेंशन दैट. इसमें एक इम्पॉर्टेंट क्लॉज जो आप डालें अगर आप ये बना रहे हैं कि किस शहर में उनकी नियुक्ति होगी, यहाँ पे हम ये मेंशन कर देते हैं दैट द एम्प्लॉयर वुड बी फ्री टू transfer the labor basically, not the employee, to any other city. So having this clause covers the fact that, because I was telling ki to actually remove, it's easier to remove an employee, but to remove a labor is actually very difficult task, because वहाँ पे फिर इंडस्ट्रियल डिस्प्यूट एक्ट उस तरीके के लॉज आ जाते हैं जहाँ पे एक बहुत लंबा प्रोसेस होता है उसको उनको हटाने का। तो आपके लिए आसान, और वो लेबर कोर्ट में भी जा सकते हैं। एम्प्लॉय के लिए तो बहुत मुश्किल है सिविल कोर्ट में जाना, बट लेबर्स दे कैन एक्चुअली गो टू द लेबर कोर्ट एंड इन्फोर्स देयर राइट्स, एंड वहाँ पे फिर यूनियन इन्वॉल्व हो जाती है इन ऑल ऑफ दिस। सो इट इज बेटर यू मेंशन इट हियर ओनली दैट द कंपनी वुड बी फ्री टू ट्रांसफर देम टू एनी अदर सिटी। जैसे इसमें लिखा है कि के अनुशोध पर आप भारत के किसी भी प्रदेश, शहर या जिले में जाकर काम करने के लिए आपको आदेश हो सकते हैं। सो बेसिकली इफ यू वांट टू टर्मिनेट, एक्चुअली दैट इज व्हाट कंपनी डू। If they want to terminate a labor, they, instead of actually saying that they're terminating, they say that you've been transferred to a altogether different city, which they know that obviously the labor won't go, and in that case though there would no other option for that labor to actually leave that job, and that would be basically you'll be avoiding a lot of labor hassles by adding this clause and by making sure that she leaves on their own. छुट्टियां कितनी रहेंगी, दैट आल्सो मेंशन यहाँ। रोजगार का समापन, या बेसिकली द नोटिस पीरियड व्हिच वी वर टॉकिंग अबाउट इन द एम्प्लॉयमेंट एग्रीमेंट इज कवर्ड इन दिस आल्सो, बट इन अ वेरी बेसिक वे, कि कंपनी से उनको छोड़ना है तो उनको कितने महीने का नोटिस देना होगा, ऑल ऑफ दैट इज मेंशन्ड। बेसिक रूल्स ऑफ द कंपनी, holidays and everything is mentioned.
I think a screen has been shared by Trade Observer. So we request to please stop sharing. Trade Observer, the name that is coming with the Trade Observer.
Is my screen visible now?
No. Yeah, now Anmolji, you are presenting. Yeah, it's visible now.
Yeah. Also, like, although these are labors and you do not expected them to have like any confidential information will be disclosed, but it is better to mention. यहाँ पे भी एक गोपनीय जानकारी करके एक छोटा सा clause होता है, so that later on you never know, like even laborers are also like operating certain machinery where certain know-how is there. So yeah, कल को if you want to actually terminate them, all these clauses are very much important, so that if later on they are actually involved in something, you can terminate them by saying that all this would amount to misconduct, because they are clearly violating the terms of their appointment. यहाँ पर भी we'll be taking all the basic documents, their पहचान प्रमाण, निवास प्रमाण, photograph, पति पत्नी का पहचान प्रमाण, everything, and later on like also ensure that they are signing all of the pages even for the labor. Now since the employment contract are covered, NDA also, it's better you sign a separate NDA if required, if the nature of work is such where a lot of non-confidential information is shared, or even otherwise the contract which I shared covers most of the such clauses, but a separate non-disclosure agreement helps, like if you are into IT or into certain fields. Now coming to the termination letter, like if you're actually terminating the employee, you cannot just terminate them by stating a simple termination that they are no longer employed or firing them. A due process has to be due process have to be followed, like you have to give them a show cause notice. Later on you have to ask them to submit a reply to it, give them a reasonable time for so that they can have a fair representation regarding an issue, and later on if you're not satisfied, then you can terminate them based on what all clauses are there, like in the agreement which I shared. So in that it was mentioned that if it is proved by the company that there's a clear violation of, there's a misconduct or violation of employment terms, then that would give the company right to terminate. So if the process is followed and you make it clear on the paperwork that there's a misconduct or a breach, so termination is there. So later on if they want to challenge it, they have to challenge it following the dispute, the clause which was there, which is very difficult. So it is better you follow your process. And also what there's one way to doing it is that if even if the employee would be knowing कि clearly termination hai, so you can ask the employee that okay, we are terminating you, but it's better that you yourself resign. And mostly the employees, they accept this offer because they also know that if in their like employment background, if it shows that they were actually terminated by a company, so then their reappointment would be difficult. So it's better, like, while actually terminating them, you give them an offer that okay, we are terminating you due to whatever reason, and it's better that you resign and we'll accept your resignation and we'll give you a good experience later, right? Okay, that because since we are also avoiding a lot of legal hassles, कि कल को अगर हम उनको terminate कर भी दें, they challenge it, or if it's not a smooth exit, so it is better, like, while actually terminating them, you give them an option. And also termination के बाद उनका जो full and final है, that also should be very much clear. मैं एक बार full and final का draft भी आपके साथ share करता हूँ कि उसमें mention सब कुछ होना चाहिए. It's not that कि you settle down their salary and later on they claim that okay, my gratuity was not paid on time, or that is there, and some other claim, there's some certain reimbursement which are not paid. So it is better to have that also. I'll just quickly share it so that we can come to the next thing. Like the full and final, it should mention everything, like what their salaries were, and now while you're doing their full and final, what all are you including, and even if there's no bonus, but you mention that okay, the employee is accepting that there was no bonus, there was no medical dues, there was no gratuity, because gratuity obligation, I think that comes after 5 years, and if the employee is not even eligible for it, but you still mention that, so that there is no claim later on, and you get them to sign this whenever you're making full and final, so that there are no other claims later on. So I think I've covered most of the documentation part, because all of this is very much important, because like you see, if we take care of all these documentation, if we do it correctly, the chances of dispute or any hassle related to employee काफी कम हो जाता है. Because जैसे हमने डिस्कस किया था, अगर if we proper offer letter, like the problems that we were discussing about the problem of employee retention. So if the employee agreement is correct, if there's a proper notice period, if we know them, okay, they cannot leave the organization, they cannot join a competitor, all of that, so the retention part is being taken care of, and that problem is solved. The other problem that we were worried about was that okay, if they leave abruptly, there's no proper handover, that also is covered. The company property which is being given to them, they'll have to hand it over, they have to give it to us in a proper manner. And the other part, that okay, any frivolous legal case if they file after leaving, that part is also covered, because we, in the offer letter itself, are laying down the mechanism by which they have to actually start a legal case, which itself is very much difficult. So वाला part भी take हो गया, तो हमारे सही documentation से ही काफ़ी चीज़ें क्लियर हो जाती हैं, काफ़ी प्रॉब्लम्स हमारी सॉल्व हो जाती हैं. टर्मिनेशन अगर हम उनको कर रहे हैं, टर्मिनेशन लेटर हमने उनको प्रॉपर वे में दिया, उनको टर्मिनेट सही तरीके से किया, और बाद में हमने कोशिश की कि उनका रेजिग्नेशन नहीं ले लें, उससे काफ़ी प्रॉब्लम्स ठीक हो जाती है. बिकॉज if an employee resigns, then they later on cannot like just say that okay, मुझे तो अब कंपनी निकाल दी, because resignation is something which they are giving on their own and company is accepting that resignation. तो वो सारे क्लेम्स उनके खत्म हो जाते हैं उस वे में, और उसमें भी हम उनका फुल एंड फाइनल ले रहे हैं. सो इफ द पेपर वर्क इज करेक्ट, एंड इसमें इट्स नॉट कि यू हैव टू इनकर एनी एक्सपेंस, केस में जाने में यू माइट हैव टू इनकर एक्सपेंस, बट दिस इज एक्चुअली समथिंग which won't require any expense if done correctly, can actually save you a lot of money. Now coming to the compliances which are there, so I would not be talking about every compliance in detail, because जैसे मैंने कहा था MSMEs हैं तो बहुत सारे तो हमारे ऊपर लगते भी नहीं हैं, कुछ तो वन टाइम ही है, जिसमें इट्स नॉट कि हमें बहुत सारी रिटर्न्स फाइल करनी है, कुछ करना है, बिकॉज लिमिटेड रिसोर्सेज, लाइक आई वाज टेलिंग अबाउट, MSME हैज टू वर्क ऑन लिमिटेड रिसोर्सेज. सो उसमें भी जो बहुत बेसिक कंप्लायंसेस हैं जो होने चाहिए, एंड जिससे हमें भी फ़ायदा है, MSME को भी फ़ायदा है, उन कंप्लायंसेस के बारे में बात करेंगे. जो सिर्फ वही कंप्लायंसेस ही ज़रूरी हैं, बाकी बहुत सारे कंप्लायंस की ज़रूरत नहीं पड़ती. जैसे बताया था, प्रोविडेंट फंड, 20 से ज़्यादा एम्प्लॉयज़ हैं अगर आपके, और तो आपके, और जिनकी उसके लिए आप PF आप अपना कर सकते हैं, जिसमें PF होगा, एंड इन द एम्प्लॉयमेंट अग्रीमेंट ऑल्सो यू कैन मेंशन ESI. आई थिंक मोस्ट ऑफ द कंपनीज दे ESI PF सब जमा कराती हैं. शॉप्स एंड कमर्शियल एस्टैब्लिशमेंट एक्ट, हर स्टेट का अलग होता है. मोस्टली लेबर डिपार्टमेंट वाले प्रेशराइज करते हैं इसमें रजिस्ट्रेशन कराने के लिए. हरियाणा में तो काफ़ी ज़्यादा होता है दैट वेन एवर लेबर इंस्पेक्टर इज गोइंग ऑन अ विजिट और रेड बोले उसको, तो दे चाहिए वही पूछते हैं कि आपका शॉप इस्टेब्लिशमेंट एक्ट कहाँ पर है. एंड दिस इज अ वेरी बेसिक कंप्लायंस. इट इज़ वेरी मच बहुत ईजी है इसको कराना, किसी भी स्टेट को आप बिलोंग करते हैं. सो कोशिश करें कि ये भी आपके पास हो. पेमेंट ऑफ ग्रेचुटी एक्ट इफ एन एम्प्लॉई, आपके पास कोई एम्प्लॉई है जो 5 साल से ज्यादा है, उसी के ऊपर एप्लीकेबल होगा इन कॉन्टिन्यूड सर्विस हो. तो देख लीजिए उन मैटर्स में ग्रेचुटी भी उनकी बनती है. एंड ग्रेचुटी कम्स जब वो छोड़ते हैं तो उसकी कैलकुलेशन भी बेसिक पे होती है. उसकी मैं वही आई कांट लाइक ज़्यादा डिटेल में नहीं जा सकते बिकॉज वेरी एग्जॉस्टिव, बट ग्रेचुटी एक्ट में भी ensure that you are compliant. Maternity Benefit Act, Payment of Wages Act, Sexual Harassment of Women at Workplace Act. At times the organizations are generally not compliant to all of this wherever 10 or more employees are working. So there's this compliance which is there. And what in NCR, lot of raids are happening and to check if we are compliant with this or not. बहुत बेसिक compliance ही है इसका. आपके डिपार्टमेंट, आपके एरिया में वुमेन एंड चाइल्ड वेलफेयर कमेटी होती है, डिपार्टमेंट होता है, वहाँ पे जस्ट फाइल अ बेसिक रिटर्न. अगर आपकी एंड एक मिसकंसेप्शन है दैट इफ देयर आर नो फीमेल वर्कफोर्स देन आल्सो वी हैव टू डू बी कंप्लायंट विद दिस एक्ट और नॉट. सो टू आंसर टू दैट इज यस, यू नीड टू बी compliant with this irrespectively if there are 10 or more people. And compliance is not of that nature कि बहुत मुश्किल होगा. उस एक्ट में काफ़ी चीज़ें लिखी हैं, लाइक आपको एक कमेटी बनानी है, कुछ करना, बट that all can be managed with the limited resources you have. So kindly ensure that you are also compliant with this act. National Festival and Holidays Act is basically कि on the national holidays, Independence Day, Republic Day, उस दिन आप you're not working, you're not making the employees work. That is all the gist to it. Factory Act में अगर आप covered हैं तो, but again Factory Act is something जिसका थोड़ा compliance को काफ़ी ज़्यादा है. अगर हम by the book चलें तो again it's I don't think that most of the companies that MSMEs would be falling under this purview, but if you are, then you have to make sure that it is there. So now I'll be talking about अगर actually कोई dispute start होता है तो आपने कैसा करना है. कोई employee के साथ कोई आपका विवाद है, कुछ है, तो then how to start with it. I think show cause notice I explained before that if there is a dispute, you have to give them a proper show cause notice mentioning what misconduct did they actually do, and you have to give them a reasonable opportunity to present their side of the case. And then if you're not satisfied with that, then you have to take this to further. And proper way would be जहाँ पे HR department है, HR take care of everything, but yeah, show cause notice should be there. It's direct termination would open you up for like legal disputes, legal hassles. So it's better to first submit show cause notice. You have to wait for their reply, and if you're not satisfied, a proper charge sheet is formed. Now while I'm talking about these disputes, the process is quite similar when I talk about employees or laborers. अगर आप लेबर की बात भी करते हैं, लेबर को भी अगर वैसे हटाना हो, लाइक आई वाज टेलिंग कि उनको हटाना बहुत मुश्किल हो जाता है बिकॉज इंडस्ट्रियल डिस्प्यूट्स एक्ट बीच में आ जाता है, देन देयर इज अ रिट्रेंचमेंट, देयर इज ले ऑफ, उस सब में जाएंगे तो बहुत मुश्किल है. तो अगर आपको किसी लेबर को भी निकालना है वांट टू फॉर मिसकंडक्ट और व्हाटसोएवर रीजन, सो प्रॉपर स्टेप्स हैव टू बी फॉलोड और एल्स दे आर अवेयर. लाइक आई थिंक दे आर मोर अवेयर दैन द एम्प्लॉइज, द लेबर पीपल, बिकॉज वहाँ यूनियन है एंड वो किसी से सुनते हैं कि उन्होंने ऐसा किया, उन्होंने ऐसा किया, एंड ऑल्सो द लॉज आर also quite protective to the labor. So I think you have to be more cautious while terminating or like while dealing with them than the employees, because employees, they are more worried about their future career, but the laborers are not, because they know that okay, even if they have this misconception, or not even misconception, the law is there, like if they are working with an organization and if you terminate them and if it's a wrongful termination, they ask for back wages. So they think that okay, अगर हम कहीं और काम कर भी रहे हैं, कच्चे में काम कर रहे हैं, एंड लेटर ऑन वी कैन क्लेम दैट ओके वी वर नॉट एम्प्लॉयड एंड वी वर टर्मिनेटेड, वी वर नॉट टर्मिनेटेड इन अ करेक्ट वे, वी कैन आस्क फॉर बैक वेजेस. सो प्रॉपर इंक्वायरी हैज टू बी डन. यू हैव टू फ्रेम चार्जेस, यू हैव टू गिव देम अ चार्ज शीट. आप एक डोमेस्टिक इंक्वायरी बनानी पड़ती है उनको, जहाँ पर उनको प्रॉपर तरीके से 3-4-5 हियरिंग्स होती हैं जो आपको इंटरनली कंपनी में करानी होती है, बट आउटसाइडर को फेयरली वो एक रिपोर्ट सबमिट करता है, उस बेसिस पे आप उनको टर्मिनेट करते हैं. in case you're not terminating them in the correct way, then that can be challenged. So to sum it up, it's like for the employee, it's like you're giving them a show cause notice, but for the labor, जो चीज हम can be solved in the earlier stage. But when you're talking about the labor, then you have to follow a very detailed process, and you actually have to do a domestic inquiry for that, and give them a fair chance, and then terminate them. Now, now I'll be talking about if the matter goes to an actual labor office or labor court, or if there's an accident. I'm covering these three scenarios. Then how to handle that? What is the best way to handle that in case? So now, if let's try to understand with an example. Like if a worker is there and you terminate them if he was not showing up, if he was not coming to the workplace. Now in that case, if you want to and वो termination सही नहीं था, and he challenges that termination. So firstly, the matter would go to a labor office, not directly to the court. So labor office में assistant labor commissioner के पास matter जाता है, जहाँ पे they basically try to reconcile the matter with the labor. दोनों parties को बुलाते हैं, आपको बताएंगे कि समझौता कर लो, ये कर लो, वो कर लो. So in that scenario, it's most of the cases, it's better if it was an actual wrongful termination to actually settle out the matter. Because if the matter goes to labor court, then again I was telling, the laws are such that it at times becomes difficult for you, because वो back wages चलते रहते हैं, उस पे चलते तो amount even 3-4 साल बाद अगर if the case is decided and if that case goes in favor of that labor, तो the amount goes in lakhs. So better to tackle the case before the labor officer itself. And in case if it's such a case where the person was not actually a laborer, or कोई like एक scenario भी discuss कर लेते हैं, because companies these days, they don't hire labor on their own, they don't keep the labor on their own roles. एक independent contractor is what we hire, and उनकी labor होती है. So with such a case, you clearly mention that, you put everything. And like I was telling, but prompt action is very much important. Whatever, if you're receiving any notice from them, you appear. And it's not that if you stop appearing, you wait for court to do something later on. Promptly, if you're replying to the notice, even yourself, even not even engaging an advocate, अगर आपकी कंपनी का कोई बंदा है, they're actually putting in the paperwork and dealing with it, तो जो labor office में है, you can deal it with yourself. But if the matter is not settled there, then the matter would go to the labor court, and then again it would be like a proper case. It will be handled like we have to give our reply, then there will be evidences. And one way to deal with like a lot of cases, like I would say even 40% of the cases, 50% of the cases, the facts are such that the laborer, she is employed somewhere else, but later on they claim back wages, or वहाँ पे they have given the statement that I'm not employed, where because that is what cases they go for. Because these kind of cases, mostly the advocates that the laborers they have is that they are working on a percentage basis. मिल जाएगा तो उनको इतना दे देंगे. So in those matters, it is better like you do you actually check it out, like if they are working somewhere or not. They are actually private expert investigators जो उनकी PF से वो return निकाल लेते हैं, like after leaving your employment, did they actually work somewhere or not. And if the case is such that they are claiming in the court that they did not work anywhere, but they actually were working somewhere, so in that case the whole case goes off. So I think you should check for that. That is something अगर आप केस में ऑलरेडी हैं, तो दिस वुड हेल्प यू. दिस पीस ऑफ एडवाइस वुड बी हेल्पफुल फॉर यू. एंड इफ देयर वाज एन एक्सीडेंट एट द वर्क प्लेस और द फैक्ट्री एंड केस इज सच, तो उस केस में क्या होता है कि एक FIR तो हो ही जाती है नेग्लिजेंस करने की. तो इट्स बेटर कि यू एक्चुअली सी दैट जो भी वट एवर मशीनरी आर द एम्प्लॉइज आर वर्किंग ऑन, जो भी सेफ्टी गियर है वो होना चाहिए वहाँ पे, because then negligence proof करना मुश्किल है. And also it is I think most of these organizations these days, they have CCTV cameras in their place. But if it's not, then it is better to have it there, because खुदा ना खास्ता अगर कोई एक्सीडेंट होता है, so ये ना हो कि because एक्सीडेंट अगर जितनी ग्रेविटी एक्सीडेंट की बढ़ती जा रही है, उतना ही क्योंकि द प्रोप्राइटरशिप कंसर्न है, कुछ भी है, तो मालिक की सीधा लायबिलिटी आती है ऐसे मैटर्स में. अगर हम इंडियन पीनल कोड की बात भी करें या फैक्ट्रीज एक्ट की बात करें, कहीं की बात करें, तो इन सच केसेस इट इज बेटर टू टेक ऑल द प्रिकॉशंस and mostly in the accident matters also. If, like I was telling, if you are registered under you're filing all the ESI की अगर उस डिपॉजिट हो रहा है तो then that is taken care of by that department only. अगर हाथ कट रहा है, डेथ हो रही है, उन that those cases also, जो पेंशन है जो भी है, that is taken care by ESI. and अगर if you are following all the compliances, then that case it's not, आपकी liability काफी कम हो जाती है. Preventive measures, we have already discussed, like in the initially only, like what are the preventive measures by which we can actually see कि हमें ऐसे issues ना face करने के लिए. Employment agreement we have already discussed. Documents must be complete. Documentation as in the employment agreement and whatever is there, it's not कि आपने sign कर लिए, not keeping a proper record. You actually keep that safe, because if an employee is there for 5 years, 6 years, 10 years, then also if there's a dispute, the employment agreement that was signed initially would be something which would be of use of then. So the documentation, everything must be complete and must be maintained. Compliances must be done. The basic compliances, ESI, PF gratuity, whatever the basic compliances are discussed, those should be there. Not talking about all the compliances, because as an MSME, limited resources and the accountability also is not that nature, because काम there are certain, आप भी अपने efforts एक बहुत limit कर सकते हैं compliances के लिए. It's not you can dedicate all of it to compliances, but the basic one should be taken care of, so that because those are for our help only. Prompt action also, I said that whatever we should not be quite relaxed to it. Whatever is happening in an organization with respect to labor and employee, if certain action is to be taken, if certain expectations are there from our side, we should do that within time. Background checks also, I think I stated that, are also very important. Background checks with respect to hiring someone, and also if there's a case going on with the labor or something like that, so in that case also it is better to actually do all the checks, so that you can also handle it in an effective way. Documents, like I was telling in the employment agreement only, that the Aadhaar card, PAN card should be with you, so that later on, because like for your organization, if you are into manufacturing, it's not that you have employees who are working remotely, but at times what happens that where the employees and everyone, they are working remotely, it's better to actually have their details, their PAN card, their Aadhaar card, the UN number, all of that should be there. And regular awareness programs like should also be organized for the workforce. Like if they are working on certain machinery, they should know what the risks are and what they need to do in case there's an accident, in case there's, God forbid, fire or or any other such event. Also, like I was talking about the Protection of Women from Sexual Harassment Act. That act itself has certain compliances where you're there's obligation of doing an awareness program once a while. That can be done like through showing them videos or something like that, what is sexual harassment, how to prevent it, but that is also part of it. So some awareness programs you can organize for labor if your organization of such a nature, so that also helps. So now I think we have reached the time, so if there are any doubts which you need to discuss, then you can ask them.
Yes, Ashok ji, you can ask the question from Anmol ji. This is the question hour session now. So members, the participants of this webinar can ask their queries. Ashok ji, you are not audible. I think you should unmute your mic.
All right, Anmolji, I have a question. Devendra Singh Murji from Mumbai.
All right, sir.
I have an employee who's been working with me in the past, where his provident fund was deducted under the scheme of below 15,000 rupees.
Okay.
All right. Now
Mhm.
his salary is nearly about 24,000 rupees and he doesn't want to deduct his PF. So what do
Okay.
we do about it?
So you want that his PF should not be deducted. He's actually
Exactly.
so in that case, if that is there, you should take that in writing that he voluntarily has made that request and then he actually want to make direct payments to it without doing any PF reductions. That should be on his request, and then maybe you can do that. Then it won't affect
But
you.
my consultant says that you cannot do that because the UN number says that once if you have enrolled under paying of PF, then he has to continue paying PF.
That won't be a violation from your side. That won't. I don't know why your consultant is saying that. Maybe to avoid any complexity. Obviously, like आप हर एम्प्लॉय की रिक्वेस्ट में तो चलेंगे नहीं तो बट अगर वो इफ insisting it and you want to take that request you can do that ऐसा नहीं कि that any
Is there a
आपके लिए कोई liability arise नहीं होगी.
Is there a notification as such where I can put it across in my files of records that this gentleman does not want to deduct his PF even after when he's crossing the minimum salary of 15,000
I understand
rupees?
that 15,000 maybe he's not wanting to have this
Yeah.
PF reductions.
Yeah, exactly. So every year there is growth. So this year he's come up to a salary of say 21,000 rupees and he says, sir, I don't want my PF to be deducted. So is there a government notification where I can keep it in records?
I believe that the notification that is already in place, so it's not of a mandatory nature. Like it's mostly like a certain direction that okay that has to be done in an ordinary course. But अगर employee की तरफ से specific request and you want to take that request, then on his request you can accept that and make direct payments if it is suitable
but
for you.
Direct payment for what? There will be no deduction of the worker, correct?
PF. Yeah, no deduction. That amount will go, which was supposed to go to the PF, then that amount he wants to be taken directly in his account. That is what his request is, right?
Correct. So that's possible?
Yeah, that is possible, but yeah, on his request only that can be done. आपके पास वो ऑप्शन नहीं है, आप खुद से नहीं कर सकते. That is what the law says. But अगर एम्प्लॉय की तरफ से वो रिक्वेस्ट आ रही है ऐसी कोई एंड आप वो एंटरटेन करना चाहते हैं, मतलब ऐसा भी नहीं दैट यू हैव टू फॉलो दैट रिक्वेस्ट, बट अगर इफ इट इज सूटेबल फॉर यू कि ठीक है कर देते हैं, एम्प्लॉय आपके लिए इतना वैल्यूएबल है एंड तो दैट केस दैट कैन बी डन. ऐसा नहीं कि दैट वुड अफेक्ट यू. ऑर्गेनाइजेशन एट टाइम्स दे डू इट.
All right. One more question. If the employee was working with me, say in the past 2 years back, and his PF was deducted, okay, he left for 2 years, and now when again he's joining me, he's saying that मेरा PF deduct नहीं हो. So is that possible under the same UN number?
Come again, आपने लास्ट में क्या बोला?
He was working with me past 2 years back. Yeah, he left the job. Now he wants to come back again and work with me, but he says I will work in a condition that my PF is not deducted.
Is there any reason to it why he's asking इसकी PF डिडक्ट नहीं होना चाहिए? ऐसा तो नहीं कहीं और भी काम करे, बिकॉज ऐसी रिक्वेस्ट जनरली तभी आती है जब उनको पता होता है कि बिकॉज एक दो जगह से PF नहीं कट सकते, तो एम्प्लॉयर वुड नो.
नहीं, बट सर अगर वो मेरे पास काम कर रहा है तो दूसरी जगह काम नहीं करेगा ना, when he's going to pay his 26 working days with me. But he says that मेरा PF नहीं डिडक्ट हो, मेरे को डिफिकल्टीज आ गई है, I have XYZ problems in my family and everything. So education of children. So उस केस में my consultant says that under the same UAN number, once if the deduction is started, you have to continue deducting. You cannot stop.
In that case, if your consultant is insisting on it, although I don't think so ऐसी कोई insistence की जरूरत है, but then you can put as an employee नहीं रखें उसको, as a contractor रख लें उसको, तो भी बात बन जाती है कि मतलब condition would be same, he would be working for you if you're sure about that कि आपके लिए काम कर रहा है.
I don't have any contractor list with my company. All are on my salary wages. Yeah.
But since you are giving an exception, you're making an exception, you can make such exception also, because उससे फिर आपकी obligations काफी हद तक बिल्कुल ही कम हो जाएंगी. उस
employee probably one by one सब जन वो करने लग जाएंगे, तो फिर क्या करेंगे?
तो probably तो फिर one by one सब PF के लिए भी बोल सकते हैं. तो if अगर आप
ESIC तो ठीक है, but PF is a big factor. 12% becomes a big amount for them.
Yeah.
So then तो they'll come up, because ESIC is hardly 0.75% to them. So that is very negligible. I think more than that amount they are recharging their phones.
That employee would be wanting his PF, but वो ESA चाह रहे हैं, but वो PF ही नहीं चाह रहे. That is what you're saying.
Correct. That's the main point. He wants the ESI, that's okay, but not the PF.
but not the PF. All right.
Correct.
So even if you ask your consultant, जो PF के norms हैं उस तरीके से ही हैं. If we read it, like I can't like share it the notification the act directly with you, but वो employer को वो option नहीं देते. But अगर employee की request पे वो आ रहा है that they don't want it, then on their request you can make the direct payment.
Can you share it to the association president, or you can share it to?
I'll email after this.
I'll get it corrected from her.
After this I'll email to you. I'll email it, and if I think I have it for one organization, we've made it. One organization did not wanted it, so उन्होंने अपने employee से ही ले लिया था ये request. तो
all right,
that request.
Priyanka ma'am, please take that noted and get those notification on the 2 points that once if a worker leaves and wants to join back, then his PF may be deducted or not deducted becomes a choice. And second, if ESI is deducted and PF not deducted.
Okay, sir, noted. So I'll ask Anmolji to share the letter with me, and
All
I'll
right.
pass on to all my members.
All right. Thank you, Anmol.
Most of them.
Yeah, Anmolji, suppose we have got some labor
हाँ जी.
through contractor. What will be our liabilities towards them? Through contractor.
सर कॉन्ट्रैक्टर के थ्रू भी प्रिंसिपल कॉन्ट्रैक्टर तो आप ही रहते हैं, तो आपकी लायबिलिटी बस यू हैव टू फर्स्टली इंश्योर कि वो अपनी कंप्लायंसेस कर रहे हैं कि नहीं कर रहे हैं, बिकॉज इफ दे आर नॉट फुलफिलिंग देयर कंप्लायंसेस देन द लायबिलिटी कैन शिफ्ट टू यू. लायबिलिटी विद रिस्पेक्ट आपने देखना है कि वो ESI PF जमा कराने के लिए वो करा रहे हैं कि नहीं करा रहे, बिकॉज इन केस वो नहीं करा रहे होंगे एंड इट कम्स टू योर नॉलेज और वो एक सब्सटैंशियल अमाउंट बन जाता है, देन दैट आल्सो बिकम्स ट्रांसफरेबल. दैट थिंग इज आल्सो ट्रांसफरेबल. आल्सो अगर कोई सम एक्सीडेंट इट हैपेंस इन योर वर्कप्लेस वो भी है. तो एंड आल्सो एज पर तो लॉ तो देखा जाए तो आपके जो मतलब आप कॉन्ट्रैक्टर को तो रख तो सकते हैं, बट सिर्फ एक जो उनसे काम कराएंगे ऐसी वर्कफोर्स से वो बहुत लिमिटेड काम है, लोडिंग अनलोडिंग उस टाइप का. अपने मेन काम अगर आप वो शिफ्ट करें तो एज पर तो लॉ भी वो परमिसिबल नहीं है, बट ठीक है वो हो जाते हैं. बट
नहीं जैसे सपोज वी हैव गॉट अबाउट 12 workers and 8 workers are from contractor, so total becomes 20. Does the PF liability come?
आपकी डायरेक्ट लायबिलिटी नहीं आएगी, बट जो कॉन्ट्रैक्टर है वो तो इज ही
उसके वर्कफोर्स पे डिपेंड करेगा ना,
उस पे डिपेंड करेगा या वो फॉलो कर रहा है कि नहीं कर रहा. आपकी डायरेक्ट लायबिलिटी वो नहीं आएगी. और आपकी वर्कफोर्स भी उस अमाउंट की नहीं बढ़ेगी कि आपने अपनी बाकी वर्कफोर्स को जो आपकी मतलब रोल पे आ रहे हैं उनको भी आपकी वो नहीं बनेगी, बिकॉज 20 का मार्क क्रॉस नहीं होगा आपके रोल्स के लिए.
ओके, थैंक यू सर, थैंक यू.
और किसी कोई
We would
क्वेश्चन?
like to request the other participants, if they have any queries, you can ask here. Sir, we would also like to move towards the chat box. We have so many queries from our participants. Like they want the format and the drafts in soft format, which you can share me, and I'll forward it to the respective member. Sir, one more question is that is gratuity applicable for partnership firms which have less than 50 employees?
Ma'am, the threshold limit for gratuity is 20, it's not 50. 20 से ऊपर है तो gratuity becomes applicable. The Gratuity Act becomes applicable, irrespective of what if it's a partnership firm, it's a private limited company, whatever it is. So the threshold limit is it's 20.
Okay, fine. So this was the chat box query. So we'd request the participants if they have any questions related to the labor issues faced by the MSMEs, they can get their queries answered.
Good problem if someone is facing in their organization or want some suggestion, they can come up with that.
Anmolji, one of my friend, he is in his factory there was death of 2 workers because of some poisoning or something, lack of air and all. He has resolved that by paying them the amount they had demanded. Factory inspector का भी सारा inspection okay. He has again got the factory license which was cancelled. The police is behind him कि आपको attempt to murder के case में. Is it okay? Means can they do that?
So like I was telling, जब कोई एक्सीडेंट होता है या कोई डेथ केस होता है तो 2 तरीके की एक हमारी लायबिलिटी अराइज हो जाती है. वन वी आर आंसरेबल टू दिस लेबर पीपल, जो आप बता रहे लेबर इंस्पेक्टर हैं, जो फैक्ट्री लाइसेंस, ये सारी चीजें देख रहे हैं। तो इंडियन पीनल कोड वो ऑल टुगेदर बहुत अलग है। अगर डेथ बाय नेग्लिजेंस या डेथ का केस है तो दे वोंट बी टेकिंग, मतलब वो इनकी इन्वेस्टिगेशन या इनकी उससे उस इन्वेस्टिगेशन में फर्क नहीं पड़ेगा, वो अपनी इंडिपेंडेंट इंक्वायरी करते हैं। तो यस, दे कैन बी आफ्टर देम बिकॉज डेथ तो हुई है एंड उनके फैमिली मेंबर्स ने किसी ने एफआईआर वगैरह करा दी होगी, तो उनको अपनी चालान कंप्लीट करना है, इन्वेस्टिगेशन पूरी करनी है, तो उसके लिए वो पीछे तो पड़ सकते हैं। ऑल्सो इफ यू सेइंग दैट इस तरीके का केस था कि सफोकेशन वगैरह से डेथ होगी, तो वहां तो दैट इज समथिंग व्हिच कैन बी डायरेक्टली एट्रीब्यूटेबल टू द एम्प्लॉयर की जो
नेग्लिजेंस ऑफ एम्प्लॉयर,
तो नेग्लिजेंस तो काफी हद तक उससे वो हो रही है। तो और प्लस अगर मैं वैसे बात करूं तो लेबर जो इनके डिपार्टमेंट्स हैं वो काफी हद तक मैनेज हो जाती हैं चीजें, तो वो अपनी तरफ से क्लियरेंसेस भी दे देते हैं। बट जो पुलिस वाले, उनको तो अपनी इन्वेस्टिगेशन पूरी करनी पड़ेगी। जहाँ पे डेथ केस है उनको पता है चलान सबमिट हमें कोर्ट में करने हैं, और वहां पे कुछ चीजें नहीं चल सकती जो यहाँ चल जाती हैं।
थैंक यू।
अनमोल जी, गुड
हाँ
इवनिंग।
जी,
मानस
good evening.
मोदी बोल रहा हूँ मैं। मेरा एक क्वेश्चन है। मेरे अभी इंडस्ट्री में 18 एम्प्लॉइज काम कर रहे हैं परमानेंटली, एंड कभी कभी ऐसा होता है कि हम लोग को कुछ एक्स्ट्रा एम्प्लॉइज डेली बेसिस में बुलाने पड़ते हैं कि अभी मेरे को और आज 10 एम्प्लॉय और चाहिए या 15 एम्प्लॉय और चाहिए, वो डेली बेसिस में होते हैं। तो पहला क्वेश्चन ये है कि आर वी बाउंड टू सबमिट ESI एंड EPF फॉर देम अदर देन आर 18 एम्प्लॉइज? क्योंकि 18 एम्प्लॉइज में मैं EPF नहीं काटता हूँ, मैं खाली ESI कर रहा हूँ। बट टेम्परेरी जो एम्प्लॉइज है, कभी 5 कभी 10 ऐसे रिक्वायरमेंट होते हैं, तो उसमें हमारे पास EPF या ग्रेचुइटी का लाइबिलिटी आता है?
जो कैजुअल लेबरर्स की आप बात करें, कैजुअल लेबरर्स की कैटेगरी में आएंगे जिनको कभी रख लेते हैं, वो परमानेंट रहते हैं, मतलब वो पर्टिकुलर एम्प्लॉइज, वो पर्टिकुलर लेबरर्स को आप लेते हैं, फिर वो बंदे भी चेंज होते हैं, रोटेटिंग है, इट्स नॉट फिक्स्ड। कभी किसी की जरूरत पड़ गई तो उनको बुला लिया, उस नेचर के हैं।
सर डिपेंड करता है, समझ लीजिए उसमें से 10 में से 5-6 तो फिक्स ही है कि जब समझ लीजिए एक हफ्ता काम पड़ा तो उनको बुला लिए, फिर उनको बंद कर दिया, वैसा है।
मंथ के कितने डेज कंप्लीट हो रहे हैं, मतलब उनकी उसमें मेजॉरिटी ऑफ द मंथ, अगर हम 30 मंथ लेके चलें तो 50% ऑफ टाइम वो है वहां पे या नहीं है? बिकॉज अगर
नहीं, 50% नहीं है, 10 दिन 10-12 दिन समझ लीजिए होते हैं।
दैट इज नॉट अ रेगुलर, वो रेगुलर नहीं है आपके लिए, तो कैजुअल लेबर्स हो गए, कभी आपने ले लिया, कब हटा दिया, तो उसकी उसमें आएंगे। वो तो आपने हेल्पर्स रखे हैं बेसिकली, जब कोई पर्टिकुलर काम वहां पे हो रहा है तो वो आपके परमानेंट रोल पे नहीं आ रहे। तो आपको डेली वेजेस में पे करते हैं या फिर उनको मंथली कुछ आपने बांधा हुआ है उनका?
नहीं, डेली वेजेस आज आए, उनका 450 होता है, हमने उसको 450 पेमेंट कर दिया, वो चले गए।
उसकी कैटेगरी में नहीं आ रहा, वो तो आप अपनी डेली नीड्स में जब कुछ आपने लोडिंग अनलोडिंग टाइप का काम करवाना है उसके लिए चाहिए, वो भी फिक्स नहीं है, और वो भी सर्टेन पार्ट ऑफ द मंथ आप बता रहे हैं लेस देन 50%, तब उस कैटेगरी में नहीं आएंगे। बट अगर सेम लोग हैं, सेम को आपने जैसे 1 महीने तक इतने दिनों के लिए रखा हुआ है, तो वो परमानेंसी आ जाती है, तो उसमें परमानेंसी नहीं आनी चाहिए। एज लॉन्ग एज देयर इज नो परमानेंसी, 20 से कम है, तो आपको फिर पीएफ की उसमें नहीं, कॉम्प्लिकेशन में नहीं आना पड़ेगा।
ओके सर, और एक पॉइंट होता है कि 18 जो परमानेंट लेबर है पे, और लोडिंग अनलोडिंग का जो हम लोग का, जैसे आपने बात बताया, वो हमने प्रॉपर कॉन्ट्रैक्ट में दिया हुआ है। तो जब भी हमारा कोई व्हीकल आता है लोडिंग के लिए, अनलोडिंग के लिए, कॉन्ट्रैक्टर के लेबर्स जो भी अपॉइंटेड लेबर्स है वो आते हैं अनलोडिंग अनलोडिंग के लिए, तो उसका लायबिलिटी तो हम लोग का कुछ होता नहीं, वो तो कॉन्ट्रैक्टर का ही अंडर में जाएगा।
वो कॉन्ट्रैक्टर की लायबिलिटी है वो तो।
अगर उनको समझ लीजिए जैसे अनलोडिंग के टाइम पे एक बार एक कॉन्ट्रैक्टर का लेबर को लग गया था, उसमें कोई रीजन से एक्सीडेंट हो गया था, सो उसका लायबिलिटी वो तो हमने पेमेंट कर दिया था, क्योंकि देखिए झमेला तो हो जाता है। तो एक्चुअल में आर वी अबाउट टू पे दैट कंपनसेशन?
See, that compensation is covered by the ESI। अगर कुछ काम करते होता है तो वो तो उसका कॉन्ट्रैक्टर ही दे रहा है, तो वो वाली लायबिलिटी उसकी। बट हाँ, अगर कोई नेग्लिजेंस आपके पार्ट पे थी, आपके वर्क प्लेस में कोई ऐसी नेग्लिजेंस थी, कोई आपने ध्यान नहीं रखा, तो वो पुलिस वाला जो केस बनता है, जैसा बता रहे हैं, जो IPC के अंदर आपका नेग्लिजेंस का केस वो बनाई, उसमें आप फंसते हैं, तो उसके पैसे आपने उससे बचने के लिए दिए होंगे, जो भी आपने सेटलमेंट किया होगा, नहीं किया होगा। बाकी
नहीं, हमारा सॉरी बोलिए।
बाकी कोई लेबर डिपार्टमेंट से था, तो उसका तो जो उनके रोल्स पे थे, जो आपने इंडिपेंडेंट कॉन्ट्रैक्टर हायर किया हुआ है, तो वो लायबिलिटी तो उसकी थी, अगर वो दे रहा था तो। मतलब आपने इतना चेक तो करना था कि जो लेबरर आपका है वो एटलीस्ट कंप्लायंसेस अपने करता है कि नहीं करता।
वो कंप्लायंसेस करता है, बट एट प्रेजेंट ऐसा कुछ पुलिस केस नहीं हुआ था जस्ट सम थोड़ा सा एक्सीडेंट हो गया था कि उसके ऊपर कुछ गुड्स गिर गए थे. इट वाज अ माइनर एक्सीडेंट, बट जस्ट फॉर फ्यूचर रेफरेंस अगर ऐसा होता है तो वो लाइबिलिटी किसका होता है?
फ्यूचर जो आपको लेबर डिपार्टमेंट रिलेटेड कोई अगर है तो वो तो इंडिपेंडेंट कॉन्ट्रैक्टर की है कि उसने इंश्योर करना था
Okay.
सारी चीजें. बाकी अगर कोई सेफ्टी हैजर्ड फॉलो नहीं होते तो ऑब्वियसली नेग्लिजेंस का केस तो बन जाता है. अगर कोई इंजरी हो रही है ड्यू टू योर नेग्लिजेंस, और अगर कुछ और इंजरी से कुछ ज्यादा हो रहा है उन केसेस में भी.
It was the negligence of the worker only. Our part was clear.
देखिए, जब केस बनता है ना तो वर्कर की नेग्लिजेंस कभी भी लिखी नहीं जाती. वो केस को बनाते ही उस तरीके से हैं कि आपकी कहीं ना कोई गलती थी, तो वो उसमें तो हम बात ही नहीं करते.
जी, ओके. थैंक यू सो मच.
किसी और के कोई डाउट्स अगर हो तो.
और भी पार्टिसिपेंट्स के कोई डाउट्स हैं तो प्लीज दे कैन आस्क.
हेलो.
हाँ जी.
हाँ सर, मेरा नाम दीपांचल है. मेरे यहाँ ना 12 to 14 वर्कर्स वर्क करते हैं, बट उसमें से जो मोस्टली जो सैलरी पे करता हूँ मैं वो कैश में करता हूँ. तो उसमें मीन्स जैसे पीएफ या ईएसआई में कुछ करना पड़ेगा मुझे या कैसे?
देखिए, अगर आप कैश में कर रहे हैं तो उस चीज से कोई रिकॉर्ड ही नहीं है. आपने अगर अपॉइंटमेंट लेटर भी नहीं बनवाया होगा मेरी तरफ से,
उसमें कुछ ऐसा रिटर्न नहीं है, क्योंकि एक मतलब रूरल एरिया में वहाँ के गांव के जो लोग हैं मतलब 7-8 लोग वहीं के ही हैं, और मेन जो ऑपरेटर वगैरह है वो थोड़ा बाहर से, उसको मैं अकाउंट में पे करता हूँ.
ओके.
तो उसके अकाउंट में पे करने में मुझे, जैसे 2-3 वर्कर हैं जो मशीन को प्रॉपरली हैंडल करते हैं, बाकी तो सब हेल्पिंग हैंड टाइप के हैं. तो जो ऑपरेटर हैं उसको मैं अकाउंट में देता हूँ, तो उसका मेरे को कोई ईएसआई या पीएफ का वो करना पड़ेगा, जबकि वो 20 का वो नहीं है मेरा.
नहीं, फिर तो कोई आपने अगर 1-2 एम्प्लॉइज हैं तो उसके लिए कोई ऐसे आपकी वो नहीं, कंप्लायंस नहीं.
4 एम्प्लॉइज हैं जिनको मैं अकाउंट में देता हूँ, रेस्ट 8 या 10 रहते हैं, वो उनको मैं नॉर्मली.
अगर मैं एज अ टोटल भी देखूं तो भी कंप्लायंसेस आपकी नहीं, आप 20 के उस थ्रेशोल्ड को पार नहीं कर रहे. और बाकी जो लेबरर्स आप बता रहे हैं वो तो उनका तो कोई प्रूफ ही नहीं ना वैसे. मतलब आप उनका रिकॉर्ड मेंटेन भी कैसे करेंगे अगर आप उनको सैलरी नहीं दे रहे? बेसिक तो स्टार्ट वहीं से होगा अगर उनको अकाउंट में सैलरी देंगे. या आप, मुझे लगता नहीं उनको आप कोई रिसीट वगैरह भी इशू करते होंगे, कोई सैलरी मतलब
नहीं, वो नॉर्मल बस पेपर पे ही होता है. ऐसा कोई ऐसा उसका वो नहीं होता है. कोई इतना बड़ा फर्म भी नहीं है, छोटा सा काम है, तो उसके लिए है वो.
आप रजिस्टर मेंटेन करते हैं एंट्री एग्जिट का, जो अगर वर्कर आ रहे हैं?
अटेंडेंस रजिस्टर है.
ओके.
सैलरी रजिस्टर कोई नहीं है.
ओके. बट वो ये कि आप जो कर रहे हैं मतलब वो बहुत, अगर मतलब ठीक है आप मैनेज कर पा रहे हो उस चीज को, बट आपने उनको मेंटेन तो किया ही है, एंट्री एग्जिट का तो मेंटेन किया है, तो लेटर ऑन वो क्लेम तो कर सकते हैं कि वो आपके पास काम कर रहे थे और सैलरी, बिकॉज वो रजिस्टर तो आपके पास रहेगा ही रहेगा. ऐसा तो नहीं कि आप वो सब कह सकते हैं मेरे पास था ही नहीं ऐसा कुछ. तो उस केस में है, वो तो है.
तो उसमें क्या मुझे अकाउंट में ही करना चाहिए या क्या, मतलब उसके लिए क्या प्रिकॉशनरी मेजर मैं ले सकता हूँ?
देखिए, अब जैसा कर रहे हैं वैसा भी कोई ऐसी कोई बात नहीं है, बट मैं कहना चाह रहा हूँ इससे आपकी वो लायबिलिटी खत्म नहीं हो रही उनकी तरफ जो है आपकी, बिकॉज वो आपकी एम्प्लॉइज, वो आपके लेबर में तो कैटेगरी में उसमें तो आएंगे. मतलब उनसे पीछे नहीं छोड़ते, बिकॉज आपने रजिस्टर मेंटेन किया हुआ सारी चीजें, उसमें सबका आप लिख रहे हैं डेली का, तो वो चीज तो रहेगी. बाकी तो आप कैश में भी दे रहे हैं तो भी रूरल एरियाज में ऐसा नहीं है कि अपने अकाउंट में डालनी है तो ही आपके रोल पे माने जाएंगे. रोल पे तो आपके हैं
वो. कई लोग ऐसे हैं जो मतलब उनके अकाउंट उनके पेरेंट्स या उनके बच्चे चलाते हैं, तो वो लेते ही नहीं अकाउंट में के.
नहीं, रोल पे तो आपके हैं, इररिस्पेक्टिवली अकाउंट में सैलरी जा रही कि नहीं जा रही, तो उससे कोई
फर्क नहीं. मतलब मेरे के ऊपर वो रहेगा उनका,
वो तो रहेगा आपकी.
तो उसके लिए मैं क्या कर सकता हूँ? कुछ मतलब ईएसआई का मैं
क्या कर
सकता हूँ, क्योंकि तो उसमें कैसे ध्यान रखने के लिए?
जैसा बता रहे हैं जितने एम्प्लॉइज हैं, मुझे लगता नहीं कोई आपके लिए कोई प्रॉब्लम आएगी. अगर इतनी है तो इसके डबल हो जाएंगे तो सोचने की जरूरत है.
कम ही रहते हैं, कभी किसी मंथ काम बढ़ जाता है तो मैं बढ़ा लेता हूँ, अदरवाइज 10 to 12 के बीच. जब तक
20 से कम है टोटल तब तक कोई इशू नहीं है. 20 के बाद दिक्कत आनी स्टार्ट हो गई, प्लस फिर देखा जाएगा कि वो भी कोई इशू हो कभी तो.
ओके.
बाकी ये कि कोई इशू अगर वहाँ पे हो गया आपका, मतलब कोई एक्सीडेंट कुछ हो गया, तो वही तो भी बात है कि आपकी लेबर तो आप ही की रहेगी वो, तो वो चीज़ आपने
नहीं
देखनी
तो
है।
वही मैं पूछना चाहता हूँ, जैसे अभी तक तो कुछ ऐसा नहीं हुआ, पर बाई चांस
ऐसा होता
कुछ
तो
हल्का
कभी
बहुत।
एक बार ही होता है, जब होता है तो वही बात है, क्योंकि
हाँ,
ईएसआई नहीं होगा उनका, तो कोई
हाँ,
इंश्योरेंस नहीं है उनकी, तो कल को तो लाइबिलिटी आपके ऊपर ही आएगी सारी, जो आएगी तो उनकी
हाँ,
आपके ऊपर
वही
मैसेज
वही
कुछ होता है
तो उसके
तो
लिए मैं
वो
पूछना चाह रहा था, उसके लिए क्या?
वैसे रिस्क है, तो आपको ईएसआई तो उनका आपको जमा कराते रहना चाहिए, वरना वो प्रॉब्लम आ सकती है। आप उनको, मतलब जो आपको, अगर आपको आपका ऐसा रिस्क वाली है, मतलब वर्क प्लेस जहाँ पे आपको लगता है
नहीं
ऐसी कोई
रिस्क
चीज हो
वाली नहीं
सकती
है,
है,
बट हाँ थोड़ा हैवी मटेरियल रहता है, तो कुछ प्रॉब्लम किसी को भी हो सकती है।
किसी को भी हो सकती है, तो इसीलिए वो चीज जरूरी है, जो
तो
ईएसआई का
उसके लिए
कंप्लायंस है ना, इसीलिए
भले ही
जरूरी है।
मैं उनको कैश में देता हूँ, पर मैं मतलब ईएसआई उनका सेपरेट करवा सकता हूँ अपने थ्रू।
करवा लेना चाहिए, आपको करवा लेना चाहिए।
ओके ओके। तो वो कितना रहता है, मतलब जैसे 12 पीपल हैं, 10 पीपल हैं, तो उससे कोई फर्क नहीं पड़ता?
वो अब उससे कम पे भी कम पे तो करवा ही सकते हैं, उसकी बात तो मैंडेटरी है, मतलब उसकी बात तो मैंडेटरी, बट कम पे भी करा सकते हैं, ऐसी कोई बात नहीं है।
ठीक है, थैंक यू।
बस।
हेलो सर, जस्ट अनदर क्वेश्चन था। बहुत बार ऐसा होता है कि हमारे जो एम्प्लॉयज होते हैं वो काफी बार अनएजुकेटेड रहते हैं। तो आप जैसे आपने पहले बताया थे कि हम अग्रीमेंट वगैरह साइन करवा ले उनसे, एम्प्लॉयज से कि लेबर से। तो एक बार ऐसा हुआ है कि नॉट इन माय केस, इन सम अदर केस आई हर्ड कि आपका वो अग्रीमेंट साइन करवाए थे, बट लेबर जो है वहां पर ऑफिस में जाके बोला मेरे को तो पढ़ना लिखना आता ही नहीं है, बट इन्होंने मेरे से साइन करवा लिया। तो उस केस में क्या प्रिकॉशन ले सकते हैं?
देखिए उन केसेस में वैसे ये वाली उनकी डिफेंस ज़्यादा चलता नहीं, बिकॉज सारे अग्रीमेंट्स में ना जो लेबर वाले होते हैं उसमें लिखा रहता है कि अगर उनको पढ़ के उनकी भाषा में चीज़ समझा दी गई है और उन्होंने उसके बाद उस पर अंगूठा और साइन किए हैं, तो अगर ऐसे मैटर्स में वो ये कहते हैं कि चलो अगर आपको समझ नहीं आता तो आपने साइन क्यों की, इतनी समझ तो थी कि साइन नहीं करना, अंगूठा नहीं लगाना। तो इन केस वो कंसेंट तो उन्होंने दे ही दिया है, तो वो वाली बातें अब नहीं चलती कि हम उतने पढ़े लिखे नहीं है, क्योंकि सब आजकल फोन यूज कर रहे हैं, सब चीजें कर रहे हैं, तो कोई भी ये चीज लास्ट में निष्कर्ष निकल के आता कि इन्होंने इनसे जबरदस्ती कराए गए हैं, तो वो कराना तो बहुत जरूरी है। आपका अगर पेपर वो किस चीज में स्ट्रांग रहेगा तो उनकी बात ऊपर नहीं रखी जाएगी, आपकी वाली बात ही मानी जाएगी कि इन्होंने साइन किया, दे आर बाउंड बाय इट।
ओके, थैंक यू।
और भी कोई डाउट्स हैं तो प्लीज आस्क, नाउ विल conclude the webinar. So participants are requested to please ask the questions if they are in mind. Anmolji, I think now they don't have any questions, so all the queries are answered. So we would like to conclude this webinar with a vote of thanks. So my special thanks to Anmolji. I deeply appreciate the presentation made by you in the webinar. Thank you so much for sharing your time, experience, and expertise with us and engaging in such a fruitful, constructive, and open exchanges of knowledge. Thank you so much, respected members and all the participants of the webinar, for your interest and attention. We hope the best for you all and success in your future. Thank you once again. So,
Thank you so much, ma'am.
now we would request the participants and they can leave the meeting.
Thank you.
Thank you.
अगर आप इस वीडियो में अब तक जुड़े हैं तो लेबर लॉ से जुड़े आपके सारे डाउट्स तो इसी से क्लियर हो चुके होंगे, लेकिन फिर भी कोई समस्या है जो आप हमसे डिस्कस करना चाहते हैं तो नीचे दिए गए नंबर्स पर कॉल करके आप हमारी टीम से बात कर सकते हैं, आपकी पूरी सहायता की जाएगी। और अगर आप चैनल पर नए हैं तो सब्सक्राइब बटन पर जरूर क्लिक करें, और अगर आपको हमारी वीडियो अच्छी लगी तो उसे लाइक करें और ज़्यादा से ज़्यादा लोगों से शेयर करें, ताकि लेबर प्रॉब्लम से जूझ रहे बाकी लोगों को भी इससे मदद हो सके। मिलूंगा आपसे अपनी अगली वीडियो में, तब तक के लिए जय हिंद, जय भारत।